Ms. Short, and we're going on to ground 2, I think.
I am, yes. So, ground 2, in short, we say that it is not permissible to refuse to recognise alternative providers of designated higher education on the basis of conditions which are not equally applicable to all recognised providers of designated higher education. In this instance, alternative providers of designated higher education do not meet the conditions for recognition under Note 1B or Note 1C because they do not have DAPS and university title, nor do they meet the conditions for recognition under Note 1C because they do not have charitable status. And we say those conditions are not, however, equally applicable to all recognised providers of designated higher education. In particular, colleges of universities and FECs do not have DAPS or university title, and universities and colleges of universities are not required to have charitable status. And in our submission, another aspect of the principle of fiscal neutrality is that all non-public law bodies must be subject to the same conditions for the purposes of recognition in respect of the same services. In other words, they must be placed on an equal footing vis-à-vis the conditions for recognition in respect of the same services. So authority for that proposition, starting with LUP, which is tab 29, please, in volume 2. So this was concerned with the exemptions at B and C, and where the conditions for recognition under domestic law were that the services were supplied under medical supervision and that 40% of the services were provided to persons insured by a social security authority or in receipt of a pension. So those were the relevant conditions. We can turn it up at paragraph 50 on page 578, please.
I'll just ask a very boring question. Are the exemptions which are given by letter, are they the same in the
6th directive?
Principal VAT directive? So where it's A, B, C, D, etc., do those correspond to those which we're looking at here, for example, in
Yes.
Article 13A?
Yes, Article 13A and Article 132 uses the same lettering for each of the exemptions. I believe there may have been a difference in relation to what is now Article 133 or 13A2, and I think those letters may have moved around a little bit. I'm sorry, I can't precisely remember, but certainly as far as the exemptions themselves in 132 is concerned, A through N or P or whatever it is the same as the letters under 13A1.
Thank you.
So turning it up at paragraph 50 on page 578, and this is the paragraph that is cited in 63 of IGMBH, which we looked at before the lunch break, for the proposition that all private organisations, all non-public bodies, be placed on an equal footing for the purposes of their recognition for the supply of similar services. So the court says, it may be stated at the outset that compliance with the principle of fiscal neutrality requires first that all of the categories of establishments governed by the private law referred to in B be subject to the same conditions for the purpose of their recognition for the provision of similar services. In the present case, therefore, it's for the National Court to ascertain whether the national legislation complies with that requirement, or whether, on the contrary, it restricts the application of the conditions in question to certain types of establishments whilst excluding others. And then at 51 and 52, the court explains there that the condition under German law, which required medical supervision as a condition for recognition, goes beyond the limits of the member state's discretion, because the term medical care covers paramedical services at hospitals by non-doctors. So recognition of non-public bodies could not be made subject to that condition when other non-public bodies, i.e. hospitals, are not subject to that condition. Next, I'd like to show you Zimmerman, which is tab 34, page 675. Where the exemption in issue was G, and where you can see it at E of the head note there. The condition for recognition in respect of outpatient care was that 2/3 of the cost, at least 2/3 of the cost of the services was met by the state. And that was the case unless the organisation was a recognised voluntary welfare association. And if we pick it up please at page 698, paragraph 35, the court accepts here that the 2/3 condition is relevant. So there was nothing objectionable per se in having a 2/3 condition. The issue, as the court explains over the page at paragraph 42, arises from the requirements of fiscal neutrality. And the issue was that in the case of the 11 organisations listed in para 23 of the German domestic law, and for your note, paragraph 418 is set out on page 693, and that provided for the exemption of welfare services by officially recognised voluntary welfare associations. And as the court explains in 42, the 2/3 condition did not apply to that category of non-public body. So at 43, the court repeats, compliance with fiscal neutrality requires that all non-public bodies be placed on an equal footing for the purposes of their recognition for the supply of similar services. And then at 45, the court sets out the German government's response that the legislation is not treating identical taxable persons differently, but merely laying down different conditions for different taxable persons. So not unlike the revenues case in this appeal. And that contention gets short shrift. At 48, the court refers again to rank, citing the principle of fiscal neutrality. And at 49 and 50, the court acknowledges that exemptions are to be interpreted strictly. Fiscal neutrality is not a rule of primary law, it's a rule of interpretation. As such, cannot be used to extend the scope of the exemption. Again, all points which the revenue pray and aid in this instance. And then at 55, the court accepts that if Germany had chosen to exercise its discretion under what is now 133A, then the principle of fiscal neutrality could not be relied upon to preclude the refusal to recognise profit-making bodies. However, as the court goes on to observe in paragraph 56, there was nothing to suggest that the member state had availed itself of that option. And we say the same is true in this instance. The question is not, as the FTT suggests in paragraph 177 of its decision, whether the UK was entitled to exercise its discretion under 133A. The question is whether it had exercised its discretion. And with respect to what is said in paragraph 51 of the Upper Tribunal's decision, it is simply wrong to say that the UK had exercised that power. As I mentioned this morning, the Supreme Court in SAE, it's paragraph 28 of its judgment, explains the UK has chosen not to exercise the discretion under 133A as far as universities and colleges of universities are concerned. In our submission, whilst member states are permitted to exercise their discretion under 133 in respect of certain of the exemptions only, if they choose to apply it in relation to a particular exemption, they are not permitted to exercise it selectively within that exemption. The condition must either apply to all non-public bodies for the purposes of that exemption, or not at all. And we say that that proposition is implicit in the reasoning of the court in IGMBH, in particular paragraph 56, which we briefly looked at this morning. If you'll note, it's page 914, tab 45. And in paragraph 56 in IGMBH, the court confirms that the requirement to recognise in exemption B must be taken to apply to all non-public bodies referred to in that provision. And in support of that conclusion, it relies on Article 133. So in our submission, that suggests that the discretion under Article 133 is either applicable to all non-public bodies within that exemption or to none at all. There is no discretion to pick and choose as between the non-public bodies within the exemption, which will be subject to the 133 condition and which will not.
I'm sure I should have picked this up, I'm sure, from reading the FTT and the UT, but what is the precise ground on which the revenue denied your clients the benefit of the exemption?
So,
Was it that they were profit making? No.
Well, no, it's that we don't come within B or C of the eligible list in the list of eligible bodies under the domestic legislation. And what the FTT says, and the Upper Tribunal agrees, is that that is essentially denying us exemption on the basis that we don't meet the conditions set out in B and C, namely we don't have DAPS and university title, and we don't have charitable status. We operate on a for-profit basis. So apropos of that second point about our distinction from FECs, the FDT and the Upper Tribunal appear to justify that distinction on the basis of the discretion available under 133A, and we say it cannot be justified on that basis because the UK has chosen not to exercise its discretion under 133A. Profit-making universities are nonetheless entitled to the exemption.
And as I understand it, you accept that as a matter of domestic statutory interpretation, your court, in the sense that you don't satisfy those conditions. So your
absolutely.
argument rests on EU law. And
Absolutely.
you may well say none the worse for that. But
Absolutely, yes.
I wonder whether you could just help me. I'm just trying to think through to understand the logic of your ground. In cases like this one we're just looking at, Zimmerman case, there's some rule, in this case of German law, which sets out criteria like the 40% point.
Yeah.
And the court is saying that goes beyond the exercise of the national authority's discretion.
Yes.
Here it's a bit different, isn't it? Because I think you said that you accepted that there's nothing wrong with the national legislature saying that the exemption applies to universities, FECs,
Yeah.
just take those two. So you're not challenging that way of doing things. Those descriptions, university, FEC, don't themselves spell out separate rules like
No.
40% point or whatever.
That's true. It's if you like opaque. The FTT took to be implicit within B and C the conditions of DAPS and university title on the one hand for item B bodies, and that C included the condition that you have charitable that the body have charitable status. So that was how you're right that the domestic legislation doesn't specify conditions in that sense, but it nonetheless is that's how the FTT interpreted the domestic legislation as laying down the condition that you have DAPS and university title to fall within B, and that you have charitable status to fall within C.
So you say that, just picking up the point you made to Sir Launcelot Henderson, that as a matter of national statutory construction, you don't say you are a university or an FEC.
No, that was the issue in FBT, was could FBT show that they were a college of a university?
But you say, well, you tell me how you put it,
So
but is it that you're
I put it
sufficiently
this way.
analogous to them? Or
No, I put it this way. I say it is not possible it's not permissible to exclude us from recognition on the basis of conditions which do not apply to all non-public bodies for the purposes of their recognition. That's how I put it. So in other words, we have been excluded because we don't have DAPS and university title and we don't have charitable status. And those are not conditions which are equally applicable. So just as Mrs. Zimmerman wasn't a organisation, a recognised welfare association, she also didn't satisfy the 2/3 condition in the provision of care. And what the court is saying in Zimmerman is that is not, you cannot apply that, you cannot exclude her from recognition by reference to that 2/3 condition when that is not a condition equally applicable to the 11 recognised voluntary welfare associations.
So it's not open to a member state to say that you qualify for an exemption if you satisfy one or more of the following, A, B, C, D, E. Because some people will satisfy A but not B, C, D, and E, and some will satisfy C but not the rest.
Yeah.
You say you can't do that.
You can do. What's missing from the domestic legislation is another category of eligible body, alternative providers of designated higher education. If we had that gateway, as the revenue describe it, then you would say, well, in order to be exempt, a non-public body must satisfy one of these gateways, A, B, or C. And we would say, well, we're an alternative provider of designated higher education, so we are subject to the same condition. So there's no, that's the problem with the domestic legislation. It's the omission of that additional gateway, and so we are being excluded from the existing gateways on the basis of conditions which don't apply equally to the conditions in B do not apply equally to FECs in C, and the condition in C does not apply equally to the bodies in B. So it's in relation, and it's in relation to, that's why I keep emphasising similar supplies. Member states can implement this legislation however they want. They have a discretion to set the conditions for recognition, but in doing that, they have to respect the requirements of fiscal neutrality. And the problem in this case arises because of the way in which the UK has chosen to implement the directive by reference to a general concept of education and vocational training rather than breaking down that concept of the supply of services. And then by reference to a list of eligible bodies. And so if the upshot of that is that we, as suppliers of similar services designated higher education, are being excluded on the basis of conditions that don't apply to other suppliers within that list of eligible bodies who also provide designated higher education, Zimmerman and Lupp tell you that's not permissible. So you could have a world in which I would say if the UK had included an additional eligible body for alternative providers of designated higher education, an exemption was subject to satisfying one of those conditions, B, C, or I'm going to call it D now, alternative providers of designated higher education, we would say everybody's subject to the same conditions, which is you have to meet one of those you have to come within one of those gateways.
So it wouldn't be permissible for the United Kingdom to say you are entitled to this exemption if you are a non-profit making body supplying educational services or you have degree awarding powers.
No,
that's not permissible.
That's not permissible, and that's because the UK has not made universities and colleges of universities subject to that condition.
Yeah.
So then Zimmerman continues at paragraph 56. And the court says here that the condition in G contemplates the recognition of profit-making commercial bodies as charitable. And that is because, as the court observes in paragraph 57, the concept of charitable is broad enough to encompass profit-making entities. So in other words, the condition in Article 133A, not to systematically make a profit, cannot simply be equated with charitable status. And so it's for both of those reasons 133A has not been implemented in relation to universities and colleges of universities. And charitable status cannot be equated with the condition at 133A that we say the difference in treatment between the appellants and FECs cannot properly be justified as an exercise of the discretion under 133A. And the FTT and the Upper Tribunal were wrong to do so.
So I'm not quite sure I've understood the point about charitable.
So
In this case, isn't They're dealing with the concept of charitable under
Under
the
G.
autonomous EU
Absolutely.
law, aren't they?
Yeah. And I'm
the
addressing
reasoning here was different, I think, wasn't it?
the recognition requirement.
No, sorry, in our case.
The recognition requirement is different in this case. I'm addressing the point that the tribunals below said that the difference in treatment between the appellants on the one hand and FECs on the other could be justified by reference to the charitable status of FECs. And the reason why that was said to be the case was that the UK has a discretion under 133A to limit recognition to bodies that don't systematically aim to make a profit. And what I'm saying is that cannot be the case because the UK has not decided to exercise its discretion under 133A in relation to universities. And having made that decision, it is not open to the UK to selectively apply the discretion under 133A.
I understand that.
And secondly, the condition under 133A not to aim to systematically make a profit cannot simply be equated as, or it's not equivalent to charitable status, because as the court explains in Zimmerman, you can systematically aim to make a profit and still have charitable status. So it's not.
That second point I'm not really understanding, because I think the point that they were making in the tribunals below was that under UK law, charities can't systematically make profits, or at least can't do so without ploughing them back. And so, as I understood the tribunals below, they're saying that is effectively equivalent to Article 133.
Yeah, and the
Whereas
court
in this case, the court is talking about an autonomous concept of charity, the European concept of charity, where it's saying that a body may be charitable even if it systematically seeks to make profits.
Well, there's nothing that precludes a charity in the UK from aiming to make a profit. What is precluded is the distribution of those profits. So there's nothing per se wrong with a charity aiming to make a profit, and lots of charities do.
No, but I think the point that was being made, sorry, I don't want to labour this, but I think the point that was being made in the tribunals below was that charitable status in relation to FECs can be seen as pretty close to a 133 case, because that talks both about not making profits systematically, or if you do, ploughing them back in.
Right, and so charitable status may tell you that the second part of that is true, but charitable status does not tell you that the organisation does not systematically aim to make a profit, because as the court explains in Zimmerman, and the position is no different in the UK, charities are not precluded from aiming to make a profit. What charitable status precludes is a distribution of those profits. So the second part of the condition in 133A may well be made out by charitable status, but my point is simply the first part of it, not to systematically aim to make a profit, is not. It's not synonymous with charitable status, either whether you're looking at it from a European law perspective or from a domestic perspective.
And if one wants authority for that from a domestic perspective, I think you've put in the bundle the Incorporated Council of Law Reporting case.
Yes.
It's all Justice Sachs.
Exactly. Yes. So it's acknowledged that charities can aim to make a profit. It's what they do with the profits that matters. So and it's a two-part condition, 133A. So then at paragraph 58, the court there rejects the proposition that member states can impose different conditions on different types of non-public bodies for the purposes of recognition, concluding in paragraph 59 that the 2/3 condition under German law could not be justified in relation to supplies of services which were essentially the same, because it only applies to some non-public bodies and not others. In other words, it was not applicable to those 11 recognised voluntary welfare associations. And then finally, can we return to life, which was tab 22. Page 404. This is in Lord Justice Arnold's summary of the relevant propositions. And at 48, he records that compliance with the principle of fiscal neutrality requires in principle that all organisations, other than those governed by public law, be placed on an equal footing for the purposes of their recognition for the supply of similar services, and that national legislation may not, in implementing the exemption provided for, lay down materially different conditions for profit-making entities on the one hand and non-profit-making persons on the other. And then page 410, paragraph 78, he concludes there that the state regulation condition under the domestic legislation for non-charitable bodies, so the domestic welfare exemption recognises charities and state-regulated welfare associations. And he concludes here that state regulation condition for non-charitable bodies doesn't infringe the principle of fiscal neutrality, because charities are also subject to regulation by the Charity Commission. And accordingly, the average consumer would see little difference between charities and state-regulated providers. So in other words, all non-public bodies were in fact subject to the same conditions for recognition, which involved some component of regulation, which from the point of view of the typical consumer, equated them. So in our submission, the jurisprudence is clear. It is not possible to impose different conditions on different types of non-public bodies for the purposes of recognition in relation to supplies of services which are essentially the same. In this instance, that means that all suppliers of designated higher education must be subject to the same conditions for recognition. And as such, the refusal to recognise alternative providers of designated higher education cannot be justified on the basis of conditions that do not apply equally to universities, colleges of universities and FECs, the other recognised providers of designated higher education. And again, to repeat the point I made at the outset, and contrary to what is suggested in paragraph 52 of the revenue skeleton, this ground is not an attempt to relitigate FBT. We don't take issue with the recognition of universities, colleges of universities and FECs, nor do we say that there cannot be multiple gateways to recognition. Zimmerman shows that there can be. Our case is simply that having recognised universities, colleges of universities and FECs, it was incumbent on the UK to also recognise alternative providers of designated higher education in order to comply with the requirements of fiscal neutrality. In particular, it was not open to the UK to exclude alternative providers of designated higher education on the basis that they do not have university title or DAPS, when the same is true of colleges of universities and FECs, or on the basis that they do not have charitable status, when the same is true of at least some universities and colleges of universities. And we say that must follow from what the court in Zimmerman says. Indeed, if the revenue are right, and member states are perfectly entitled to introduce multiple gateways to recognition with different conditions for recognition attaching to each, then the answer in Zimmerman would have been very different. The issue in Zimmerman was not with multiple gateways to recognition. The issue was that different conditions for recognition applied to the different gateways. So we say it is no answer to say, as the revenue do in paragraph 53 of their skeleton, that the appellant's problem is that it doesn't meet the conditions for any of the gateways. That was also Mrs. Zimmerman's problem. She didn't meet the 2/3 condition, and nor was she an officially recognised voluntary welfare association. The question is whether the conditions for recognition are equally applicable to all non-public bodies in relation to the supply of similar services. In that regard, the services in issue are designated higher education, and the answer is no. So, and as I mentioned a moment ago, in effect, the defect in the domestic legislation is that it is missing a gateway for alternative providers of designated higher education. So unless I can assist you further, I'm going to hand over now in relation to ground 3 to Mr. Blades.
Yes, thank you. Mr. Blades.
Good afternoon, my lords. So I'm going to deal with issue 3, which is TEFL, and this is an issue that applies only to the third of the appellants, to Interactive Manchester. In short, our submission is that IMAN is recognised as an eligible body under Note 1F, and accordingly it's entitled to exemption in relation to all of its supplies of education, and not just its supplies of TEFL courses. That, I say, is the natural reading of the legislation once the elements that are incompatible with EU law have been disapplied. And in particular, I say it's Note 2 of the legislation that requires disapplication. So if I can, I'd like to start by returning to the legislation just to make a few short points on that. And if I can take you to page 9, which is in tab 1, volume 1. This is the PVD. So there's 3 points on the PVD. The first is, you can see next to the number 1, member states shall exempt the following transactions. So if you have a transaction that fits the description that follows, it's mandatory for the member states to exempt it. The second point to make relates to the exemption, the education exemption itself and the supply condition. And the point that I make in relation to that is that the concepts of children's or young people's education, school or university education, vocational training or retraining are autonomous concepts of EU law. And in particular, the one that we focus on is school or university education. And if I can quickly show you the meaning of that expression, it's referred to in the case of Dubrovin, which is in volume 3 of the authorities bundle, tab 42, page 826. I will be coming back to the PVD, so it might be useful to leave that open. And it's paragraph 28 that explains what this concept means. And what the CJEU says is that it refers to an integrated system for the transfer of knowledge and skills covering a wide and diversified set of subjects, and to the furthering and development of that knowledge and those skills by the pupils and students in the course of their programs. So that's what the concept means in EU law. And if you go to the previous page, paragraph 21, you see that famous formulation of how the exemptions need to be interpreted. So they have to be interpreted strictly. And then at 22, you can see, however, that strict nature of interpretation doesn't mean that they can be denied their meaning. And in fact, Dubrovin is a good example of what the autonomous concept of education means for member states, because in that case, the CJEU explained that Germany didn't have any discretion in determining what the subject of the supply that was exempt would be. The fact that this was swimming lessons and that didn't fall within the scope of the exemption meant that it couldn't be exempted. So that's the point I make about the supply condition, is that it's an autonomous concept and there's no discretion to define or restrict the scope of that concept. And just for your note, that's not a point that's unique to the education exemption. That's a point that applies to the subject matter of all of the exemptions. Just for your note, page 851, tab 44, is the Advocate General in the case of EQ, and it's paragraph 74 that I refer to, where it's explained the substantive definition of the exemptions cannot be altered. So that's the same point. It's an autonomous concept. You cannot restrict the meaning of the supply element. There's no discretion in that regard. So back in the PVD, which is page 9 of the authorities bundle, the third point I make about the language of the directive is the point that when you get to the supplier condition, the point at which the member state has discretion, what it's discretion to do is to recognise organisations as having similar aims. But the focus is on the organisation. That is who's recognised. It's not a particular supply that's recognised, it's the organisation. Now, of course, that doesn't mean that a recognised body's supplies will all be exempt. They still have to fall within the supply element of the definition. So, for example, one case that deals with this, that I will come to in a moment, is the Commission in Germany. And Commission in Germany is authority for the proposition that research does not fall within the scope of education. So it doesn't matter whether a body is recognised or not if what it's supplying is research, because it's not going to fall within the supply element of the definition. So those are the 3 points I wanted to make on the directive. Moving to the domestic legislation, page 73 of the authorities bundle, which is tab 5. The first point I make is that there's no distinction in the domestic legislation between the bodies that are recognised with regard to education and with regard to vocational training. The concept is the same. It's the concept of an eligible body. The next point to make is in regard to note 1F, so this is page 75. And this is the part of the definition of eligible body that Iman relies upon to say we are recognised by the UK. And the point I make about note 1F is the recognition is not partial. Recognition is not in respect of certain supplies. It's a recognition of the organisation. If the organisation provides the teaching of English as a foreign language, it's an eligible body. The third point on the domestic legislation is note 2. And what I say about note 2 is that it doesn't de-recognise an entity that falls within note 1F. That's not what it does. What it does is maintains that that body is an eligible body, but takes some of its supplies outside the scope of the exemption. So you can see the language is a supply by a body, which is an eligible body within note 1F, shall not fall within this group unless it's TEFL. So if you have a body that's providing TEFL, it's an eligible body because of note 1F. All of its supplies of TEFL are exempt, but what note 2 it does is says even though you're an eligible body, if you're providing another form of education, you're not within this group, you're not within group 6, so the supply isn't exempt.
Well, you are within the group, but only insofar as you're supplying TEFL.
Well, my lord, the supply doesn't fall within the group. That's what note 2 says. A supply shall not fall within this group. So I completely agree. The provider remains in the group. It remains an eligible body, but certain of its supplies are taken outside the scope of the exemption, despite the fact that it's an eligible body.
And you say whether a body is eligible or not is a binary question.
I do.
Either you're eligible or you're not eligible, recognised or not recognised. So, yeah. I mean, would it be permissible for a member state to say, well, what we really want to do in our educational system is we want to encourage apprenticeships and science degrees so that we will allow vocational training to begin and universities insofar as they promote science. That's permissible or not?
Just to check I understand the question correctly, it's the point I think you're making, my lord, is you can have different recognition criteria for vocational training as opposed to education. My primary answer is no, you cannot do that. But perhaps the more helpful answer in this case is I don't need to go that far because it's common ground that the supplies in relation to which Iman seeks exemption were supplies of education. And I suppose whilst I'm there, I will just show you the 2 points of common ground that I rely upon. So this is in the Upper Tribunal's decision. The first, so this is tab 6 of the core bundle. So the first point of common ground, I'll explain what it is and then I'll show you the references. The first point of common ground is that Iman is an eligible body within note 1F. And you see that at paragraph 23 on page 80. And you see that in paragraph 66 on page 90.
56, did you say?
Paragraph 66,
66.
on page 90. The second point of common ground is that the supplies that Iman made were supplies of education. And for that, I point to paragraph 7 of the Upper Tribunal's decision, page 77.
Sorry, give me the paragraph again.
Paragraph 7.
7.
So those are I say are the only findings that Iman needs, and they were common ground, and understand remain to be common ground. So in terms of my submissions, I'm going to make 3 broad points, and then I'm going to show you the tribunal's decision. So the first of the 3 broad points is that recognition is a binary concept that applies at the level of the organisation and not the level of the supply. In other words, an organisation is either recognised or it's not. The second point I'm going to make is that once the UK recognised Iman as an organisation with similar objects to a body governed by public law, the UK was obliged to exempt all of its supplies of education. And the third point I make is that Note 2 was contrary to EU law. Note 2 was the only part. Note 1F was not contrary to EU law. The result is that Note 2 must be disapplied, but Note 1F need not be disapplied. So the first of those broad points, recognition is binary, applied at the level of the organisation. The first point I make is the one I've already shown you, which is the language of the directive. It's the organisation that's being recognised, not any particular supply. In determining whether an organisation should be recognised, in determining whether it has similar objects, the Court of Appeal in Open University, a case that my Lord Justice Lewison was very familiar with, essentially decided that similar objects means the same objects. And if I can just show you the extracts of that I rely upon, it's it's in the volume 2 of the authorities bundle. It's tab 20 and it's page 341. So this is the Chancellor's judgment with which the other members of the court agreed on. Sorry.
I think there may be I'm sorry, tab.
It should be tab 20.
That's the FBT.
That's FBT.
Yes. Perhaps it's the previous tab, is it?
19.
19, I think.
19, my apologies. It was page 341. So this is the Chancellor's judgment, but there was no disagreement between the members of the court on this point. And there are 4 paragraphs I want to show you. Paragraph 87, you can see the question is posed, what does similar objects mean? And you can see the Chancellor asking the question by reference to the organisation. So he's asking it by reference to the BBC. He's not asking it by reference to any particular supply that the BBC is making. So that, I say, is entirely consistent with the language of the PVT, which I showed you a moment ago.
Does that mean objects are different from aims in that word?
Well, I was going to go on to say, my lord, paragraph 93, which I'll show you when I get, that's the fourth of the paragraphs I want to show you.
Yeah.
Seems to imply that objects and aims are the same thing. Because what the Chancellor says is the test for public bodies is whether they have the same objects. The tests for non-public bodies is whether they have similar aims to that. They should be interpreted essentially as the same test. So I can take it now. Paragraph 93 in my submission is authority for the point that objects and aims in the PVD means the same thing.
But the BBC presumably had all sorts of other objects as well. I mean, I don't suppose
Absolutely.
anybody would say that Strictly Come Dancing is educational.
Well, I wouldn't wish to opine on that question right now, my lord. But that's exactly the point that that I will be making in due course, because when Lady Justice Arden comes to consider the all or nothing rule, as she calls it in FBT, she gives Open University as an example of a case where just because an entity, the BBC, has similar objects doesn't mean all of its supplies are exempt. So its supply of Strictly Come Dancing, for example, is not exempt. And the point I'll be making in due course is that that is all that Lady Justice Arden is saying in FBT. But my lord is quite right. The BBC will have lots of aims, and the point needs to be assessed holistically whether the organisation has a sufficiently educational aim. In other words, the assessment is at the level of the organisation, considering the totality of its supplies. You don't focus on a particular supply or a particular portion of those supplies and ask what was the entity's aim in making those supplies. No, you look at the entity holistically. Now, I'm sure my lords have got the point, but just to make it clear, because we jumped ahead to 93, HMRC's submission in Open University was that similar objects means the same object, so one of the 6 types of education listed in the PVD. That's paragraph 89. Paragraph 90, you see the Open University submission. It means something else. And then 93, you get the Court of Appeal rejecting Open University submission. So in other words, upholding HMRC's submission that similar objects means an object of providing one of the types of education listed in the PVD. Now, the reason I show you that is because the point I take from it is that there's no separate object of providing TEFL. That is not a basis upon which an entity can be recognised. If a TEFL provider is recognised, as they are in the UK, that is because Parliament has decided that they have the aim of providing one or more of the 6 types of education in the PVD. And that, I say, is the crux of Mr. Justice Richard's error in the Pilgrim's case. And I will show you that when I deal with the tribunal's decisions. But essentially, his analysis is TEFL providers are only recognised because they have an aim of providing TEFL. So it's only their TEFL courses that get exemption. And the answer to that, I say, is the premise is wrong. TEFL providers aren't recognised because they provide TEFL. They're recognised because they provide one of the 6 types of education listed in the PVD.
Just in assessing these submissions, do you accept that one really sensibly has to read notes 1F and 2 together? In other words, to make sense of them.
Well, I appreciate they're dealing with the same subject matter.
But they're 2 sides of a coin, aren't they?
No, I dispute that, my lord. One is dealing with recognition of the body. That's note 1F. The other is dealing with which supplies by that body fall within the scope of the exemption. So in my submission, they're dealing with different things. They obviously both relate to TEFL, but they're not dealing with the same point in my submission.
One way of looking at it is that one is essentially a sort of proviso to the other. You could read it as saying that to the extent it provides TEFL, it's treated as such a body. It just happens to be divided into 2 separate sentences.
Well, my response to that is that that's not what it says. It doesn't say that recognition is limited in some way.
Wasn't that rather the thrust of the way Mr. Justice Richards dealt with it in Pilgrim?
It was,
Two together. It seems almost glaringly obvious that the intention was to provide the exemption pro tanto. I mean, to the extent you provide TEFL, but not further or otherwise. Otherwise, it would be a kind of open sesame and absolutely anything in the higher educational field that was being done by the body in question would suddenly get a magic exemption. Well, what could be the possible point of that?
Well, my lord, I don't need to reach a view on this point, but it's quite possible that there is some qualitative threshold in what it means to be a provider of TEFL. That might be a point that the revenue wish to take in another case. So it may be that only certain entities that provide an element of TEFL would fall within note 1F. That's a quite possible interpretation. But as I say, I don't need to pin my colours to the mast on that point, because it's common ground in this case that Iman is a provider of TEFL within note 1F. So that's Open University. There is no discretion in which supplies to exempt. That is not a recognition of an entity or a decision not to recognise an entity. And in any event, a member state has no discretion as regards the supply element, as I showed you in Dubrovin a moment ago. So Parliament could not have said, for example, we recognise universities because they have the aim of providing education, but they're only eligible insofar as they're teaching law. That would not be a recognition of an organisation, and it would involve an impermissible restriction on the supply element of the definition. So in other words, recognition is binary in the sense that an organisation is either recognised or it's not. Its objects don't differ from supply to supply. The organisation either has the same objects as a body governed by public law with such as its aim, or it doesn't. And if I can take you to, I hope I've got the right tab, tab 18, yes, volume 1, and this is the Upper Tribunal's decision in FBT. Now, this case was concerned with Note 1b, whether FBT was making supplies as a college of a university or not, and the supplies in question were made in conjunction with the University of Wales. Now, the FTT had concluded that FBT wasn't a college of a university, but in the process of so deciding, its view was that FBT, you look at FBT's supplies in the round to work out whether it's a college of the University of Wales. You don't just look at its University of Wales supplies. And that was the point that was challenged in the Upper Tribunal. If that compartmentalised approach, as I will call it, was correct, if it was correct that you could look at only the University of Wales supplies, then it would be possible that FBT was an eligible body in one capacity, but not an eligible body in another capacity. And if I can just show you what HMRC said about that in FBT, it's page 318, paragraph 15. HMRC submitted that a body was either an eligible body or it was not an eligible body. It was not possible for a single body to be an eligible body in relation to some of its activities and not an eligible body in relation to the remainder of its activities. So the point that I'm making was HMRC's submission in FBT. That was the view that Mr. Justice Morgan reached in FBT as well. And if we can start at paragraph 17, it's helpful to note, I think, that the heading above 17 is an eligible body. He's dealing here with Note 1 generally. He's not dealing with Note 1b. And you can see that when we go through the decision, because the heading above 35, paragraph 35, is any college, institution, school of a university. So that's where Note 1b analysis starts. So in other words, paragraph 17 and the paragraphs that follow, that's where he draws out the general principles that apply to Note 1 generally. And then paragraph 35 is where he applies that to Note 1b. So, paragraph 24, page 319, this is part of the general analysis of Note 1. And the point that he makes is that the language of the PVD makes it clear that a body is either recognised or it's not. It says, taking the language of the directive alone, the process requires you to ask two separate questions. Is the body claiming the exemption a body which is specified? And two, is the supply for which exemption is claimed within the description of the exempted supply? If the first of these questions is answered no, so if it's not recognised, then the second question will not arise. If the first question is answered yes, i.e. it is recognised, then the second question will arise, but it can be answered yes or no according to the relevant circumstances. There is no sign in the language of the directive that the first question will depend only on the activities for which the exemption is claimed. And then 5 lines up from the bottom, he says another way of putting it is to say that when answering the first question, the answer is either yes or no. The body is either specified or recognised or it's not. The question may not be answered by saying in relation to some of its activities it's recognised, but in relation to other of its activities it's not recognised. So that's the reasoning from the language of the PVD. And then over the page, paragraph 25 and 26, the point he makes is that the same principle can be gleaned from the language of the domestic legislation. there are two separate questions, and a body is either recognised or it's not. Paragraph 27 is very useful in this case because it explains how that principle applies specifically to Note 1F. If I could invite the court to read 27. So that was the analysis on Note 1 generally. Note 1B is then analysed specifically starting at paragraph 35, and at paragraphs 37 and 38 Mr. Justice Morgan says the same conclusion applies in relation to those. So you don't just look at the University of Wales supplies, you look at all of the supplies. That was the conclusion on Note 1B. Now this was a case that the appellants in this case relied upon in the Upper Tribunal, and the Upper Tribunal's response was not to say that it didn't support the appellant's case, but to say that it was overruled by the Court of Appeal when FBT got to the Court of Appeal. And that, for your notice, paragraph 70 of the Upper Tribunal's decision, tab 6, page 91. We say the Upper Tribunal was wrong in that regard, and what Lady Justice Arden decided in FBT needs to be read in some detail and can only be understood by reference to the cases that she cites to support her analysis. So this is behind tab 20, and the case starts at page 358.
Just before you go there, just on paragraph 27, what's your submission as to where Mr. Justice Morgan actually landed on that point? Because he seems to be saying it's a bit different. He seems to be saying that, because he's treating it as if it's both parts of the note work, as it were. And he seems to be saying, yes, it may be that the note 1F, you say it is an eligible body, but he then seems to give effect to 2 by saying, but it only applies insofar as those particular supplies are concerned.
Well, the way I read 27 is that he's only talking about the recognition element, because of course this is the part of the decision where he's dealing with how to recognise an entity. And what he says is Note 1F is slightly different from the other parts of Note 1, in that all that's required is some provision of TEFL, no matter how significant a part of your overall organisation that is. If you provide some TEFL, you meet the Note 1F language.
But he wasn't concerned with the question that you've raised here, which is the suggestion that you give effect to Note 1F, but cross out Note 2, which is the substance of your submission.
I agree, and I'm showing you this merely to show you one of the building blocks of my argument, not because I say it's a complete answer. And the building block I take from Mr. Justice Morgan's decision here is that it doesn't matter what the other supplies you make are, if you provide some TEFL, the organisation as a whole is recognised. As he says, irrespective of the significance of the TEFL.
Thank you.
I should say that it's not only paragraph 27 of that case that I rely upon. I say the whole analysis of note 1 is supportive of my construction of the PVD, which is that recognition is binary. So I was going to go to the Court of Appeal's decision in FBT, which starts at 358. Now the arguments had shifted from the Upper Tribunal. There was no longer an argument about Note 1b before the Court of Appeal. And the reason for that was that 2 days after the Upper Tribunal's decision, the CJEU released the decision in MDDP. And that prompted FBT to shift its argument to say, okay, the domestic legislation might not be on our side, but there's a breach of fiscal neutrality because universities are treated one way and we're treated another way. And the way in which FBT said that that difference manifested itself is at paragraph 25, which is page 365. So Ms. Hall, who was for FBT, said there were 2 rules that applied to FBT that didn't apply to universities. One was a mainly acting rule, and the other is the all or nothing rule.
Sorry, where are you?
I'm in paragraph 25 on page 365.
Oh, I see. Yeah, got it.
And you can see in the passage, well, you can see in 3 lines down in paragraph 26 what the all or nothing rule is, or what FBT said the all or nothing rule was. And that's once a person is entitled to the education exemption, all supplies of education are exempt. That's the all or nothing rule. So the question for the Court of Appeal was, well, is there an all or nothing rule? And they answer that at 33. Lady Justice Arden answers that at 33, which is the paragraph that the Upper Tribunal in this case relies upon to say the Upper Tribunal's decision in FBT is not reliable. And if I can invite you to read paragraph 33, please. So I say there are 2 points to take from that paragraph. The first is that the first sentence is not dealing with what the law is, it's dealing with what HMRC's approach to the law is. So you can see there's no evidence that HMRC applies an all or nothing rule. So that's just saying what HMRC's practice is. The second sentence onwards is making the point that being an eligible body does not mean that every supply that recognised body makes will qualify for exemption. And I say it's important to read that paragraph in light of the cases that are cited. So the 2 cases that are cited are Open University, the case that I was discussing with my Lord Justice Lewison a moment ago. Now that's a case where the BBC was an eligible body, but that didn't mean that its supply of Strictly Come Dancing qualified for exemption. The fact that you're an eligible body does not open up all of your supplies to exemption. It has to fall within the confines of the supply element of the definition. And I say the other case that's cited, Commission in Germany, makes exactly the same point. So Lady Justice Arden is saying it can't be right that there's an all or nothing rule, because if there were, then a university's research would be exempt. And Commission in Germany shows that that's wrong. So I say that paragraph 33 of the Court of Appeal in FBT is making the respectfully obvious point that recognition or qualification as an eligible body does not qualify you for exemption for something other than education.
Why then is she disagreeing with the Upper Tribunal? Because in paragraph 24 of the Upper Tribunal, Mr. Justice Morgan says there are two questions. Is the body claiming exemption a body which is specified? And is the supply within the description of exempted supply? So that's exactly what Lady Justice Arden is saying. So where's the disagreement?
Well, the way I read, the way I invite the court to read FBT is that Lady Justice Arden is saying, to the extent that Mr. Justice Morgan was saying that your supplies other than education are exempt.
He's saying exactly the opposite in paragraph 24.
I agree, and it's difficult to make sense of why the cases that are cited in paragraph 33 are cited if it's that narrow point that's being made by Lady Justice Arden. So I say, in context, the better reading of FBT in the Court of Appeal is that to the extent that Mr. Justice Morgan was saying all of your supplies, be they education or be they something else, are exempt, then he was wrong. If Lady Justice Arden is saying some supplies of education that you make are not exempt, even though you're an eligible body, then reference to Open University and Commission in Germany would make, in my submission, very little sense. Because that's not a point that those cases make. The other case I wanted to show you is Pilgrims in the Court of Appeal. And I just want to show you one passage for now. That is volume 1, tab 15, page 267. I will take you through Pilgrims in more detail in due course, but I just want to show you one passage now because it's, I say, directly relevant to this point. And it's paragraph 4 of Lord Justice Sheeman's conclusions on the proper construction application of the directive. You can see 5 lines down.
Are you?
I'm on page 267 of the authorities bundle. And I'm in numbered paragraph 4, which is the penultimate paragraph on the page. And I'm 5 lines down in that paragraph. It says, when one looks at the whole list of circumstances set out in 13A1, the Commission has left to Member States the task of identifying the relevant bodies, but has not left to Member States the option of refusing to exempt supplies when made by eligible bodies, while accepting that exemption for those same supplies would apply to bodies governed by public law. So I say that's the same point that Mr. Justice Morgan was making, and the same point that I say Lady Justice Arden was not rejecting, which is you look at the body, you look at that at the organisational level, you ask, are they, do they meet the supplier condition? If they do, it follows that all of their supplies of the stated description are exempt. So that was everything on the first big point. Yes, the submission is that recognition is binary and it applies at the level of the organisation. The second point is that the consequence of recognition is that the UK is obliged to exempt all supplies of education.
That's a different way of proving the same point, isn't it? Is it a different point?
It certainly overlaps. I suppose that the point is this. Point one, recognition is binary, doesn't answer the question of what it is that gets the exemption, which supplies it is that gets the exemption.
You said it's the supply falling within the description of the exemption.
That's right, and I was just going to put those 2 points together, but there was nothing more than that on point two. The third point is that the result of all of this is that note 2 must be disapplied. So the UK was obliged, having recognised TEFL providers having similar objects, to exempt all supplies of education. There is only one offending provision, and that we say is note 2. It's note 2 that says that some supplies of education by an eligible body are not exempt. There is nothing wrong with note 1F. The UK was perfectly entitled to say, we consider TEFL providers to have the aim of providing education. The UK was perfectly entitled to do that. Note 1F is not a partial recognition, it's a full recognition. If it were a partial recognition, then there may be an issue with whether that complied with EU law, but it wasn't. So the result is that note 2 is disapplied, but note 1F is not disapplied. Just for your note, they're not in the bundle, but the principle of supremacy of EU law has been abolished by virtue of the retained EU Law Revocation and Reform Act 2023.
That was after the events we're concerned with.
And that's the point. It doesn't, that abolition does not affect this case. So the FTT and the UT, they both decided this point on the basis that they were bound by Mr. Justice Richard's decision in Pilgrims. And for your note, that's paragraph 247 of the FTT at page 149 of the core bundle, and paragraph 72 of the Upper Tribunal, which is page 91 of the core bundle. Now, Pilgrims was primarily a case about single and multiple supplies, and whether various components of residential TEFL courses were separate supplies or were all part of the same supply. That was the primary issue, which we don't need to touch on. However, there was a remaining issue which concerned the question of whether Pilgrims was entitled to exemption in relation to vocational courses that it taught. So these were teacher training courses. And the basis of its argument was, we're an eligible body under Note 1F. This is vocational training. We should get the exemption for that vocational training. And Mr. Justice Richards rejected that in the High Court. And this is tab 14, page 253. And his reasoning, the relevant reasoning is just 3 lines above the letter H. On page 253 at the end, he says, the effect of notes 1 and 2 is to define language schools only insofar as their aim or object is the teaching of TEFL. Accordingly, an essential trigger for the application of the vocational training aspect of Article 13A1I is absent, and pilgrims falls outside the scope of the exemption. So his conclusion is based on the premise that what Note 1F is doing is granting a partial recognition. And the basis for that is that he says it's recognised because its object is the provision of TEFL. And that, we say, is the crux of his error. Pilgrims wasn't recognised because it had an aim of providing TEFL. When one looks at Open University and sees what similar objects means, it must be accepted that TEFL providers fall within the scope of the exemption because the UK has recognised them as having one or more of the educational aims listed in the PVD, of which TEFL isn't one. And that, we say, is why, when the case got to the Court of Appeal, although the point wasn't argued, it was common ground, Lord Justice Sheeman was right to express hesitations about the correctness of the point. And you can see that on the page we were on a moment ago, 267. But this time it's paragraph 2. I want to show you. 5 lines down, he says, it's been common ground that member states are at liberty to define organisations in such a way that where an organisation carries out several of the activities set out in 13A1I, some of them are excluded. So that was the common ground. Thus, education could be included, but not vocational training. I would not wish to be taken as necessarily assenting to what appears to be common ground, but there is no need in this judgment to elaborate why I have hesitations. So we say Lord Justice Sheeman is casting doubt on the very part of Mr. Justice Richard's decision that's relied upon by the revenue in this case. Now, whilst he doesn't elaborate on his hesitations, we respectfully submit that they stem from a plain reading of the directive. The directive makes mandatory the exemption of education and vocational training supplied by bodies that are recognised. That's a discretion to recognise, not a discretion to pick and choose between the categories of education supplied by those recognised bodies. Accordingly, we submit that Mr. Justice Richards was wrong. The Upper Tribunal in this case was wrong to follow his decision, and we invite you to conclude that Note 2 is an impermissible restriction on the exemption of educational supplies by a recognised body. The result, we submit, is that once Note 2 is disapplied, all of IMAN's supplies of education qualify for exemption, not just its TEFL. I want to deal very briefly with the points that HMRC make, and there are 7 of them. So the first is, this is paragraph 66 of their skeleton arguments. 66 and 67. And the point that's made is that the Kugler line of authority, so Kugler, King's Crest, Dornier, Zimmerman, I think are the cases that are cited, show that a member state can recognise a body as having similar objects in relation to only some of its supplies. And there are 2 points to make here. The first is that's not what the UK has done in Group 6. It hasn't only recognised IMAN in relation to some of its supplies, it's recognised it in relation to all of its supplies, and then taken some of those supplies outside the scope of the exemption. But the second, more fundamental point is that those cases do not support a partial recognition. What those cases do is set out factors that are relevant in determining whether an entity is charitable or devoted to social well-being. And every one of those cases phrases the test as being whether the organisation or the taxpayer is recognised. Not one of those cases suggests that recognition can be partial or on a supply-by-supply basis. Indeed, two cases of particular note. One is Zimmerman. If it were the case, and Zimmerman, you'll recall from earlier, was the case where there was a 2/3 funding requirement. If it were the case that funding of your activities was an important factor to take into account, and only some services were funded by Social Security, one might expect the Court of Justice to have said, okay, the supplies that are funded by Social Security are charitable, you're recognised in relation to those activities, but in relation to you're not, in relation to the rest, you're not recognised. That's not what the Court of Justice does. It sets out the factors and directs the National Court to make a holistic decision on whether the entity is devoted to social well-being. The second point, and I make the same point in relation to this case, is EQ. EQ was a case, we've not seen it yet, but it's a case about a barrister in Luxembourg, some of whose supplies were for vulnerable adults. And again, the court says, you need to look at his overall business. You can't say some supplies are devoted to social well-being and some aren't. You look at the overall business and the extent to which that business is devoted to social well-being. So the point I make in relation to point 1 of HMRC is the cases do not support partial recognition. HMRC's second point is that there's a practical difficulty with our case, that it would only be possible to have a single supplier condition. Simple response to that is we do not understand why that's a natural consequence of our argument. You can have as many conditions as you like, in theory, subject to fiscal neutrality, but if those conditions are met, then all of your supplies that fall within the scope of the PVD are exempt. Point 3 is that it's said that my approach inevitably involves a breach of fiscal neutrality. And the answer to that is, well, it depends which conception of fiscal neutrality you adopt. If the revenue are right, that a distinction in supplier, one being recognised, another not being recognised, means that you can have a difference in result without breaching fiscal neutrality, then there would be no breach of fiscal neutrality here, because any entity who is recognised by virtue of its provision of TEFL would be recognised. It would be in a different position to an entity that's not recognised. So the point in relation to fiscal neutrality is, on HMRC's case, there is no breach of fiscal neutrality.
That's not your case.
It's not my case, no.
Because your case is that you can't have, as it were, a selective approach.
It is, but
because you look at all education.
If we are right on fiscal neutrality, then ground 3 is essentially irrelevant.
Yeah, but leaving aside the earlier grounds, as I understand it, you say, for example, that you couldn't have a rule of recognition that universities are exempt to the extent that they do law courses.
You couldn't limit
they supply education in law.
You couldn't limit the exemption to just legal education. That was the point I was making earlier.
But isn't that really what your interpretation of the two, of 1F taken on its own does?
Well,
It
no,
says
no.
that you've got this institution, which is your client, that supplies all sorts of education, but it's only exempt to the extent. Sorry, this is if you. Sorry, I'll go back a step. the two bits of the rule, and this goes back to a question I asked you earlier, really go together, it seems to me. And they're saying, yes, you're exempt, but only to this extent.
Well, I suppose my answer is the same as earlier, that note 1F is not singling out specific supplies and saying you're exempt in relation to those specific supplies. Note 1F is not dealing with the type of supply that is subject of the exemption. Note 1F is just the recognition element. The bit that deals with what supplies are exempt is right at the top. It's in item 1.
But suppose you have two institutions, and neither of them is independently recognised for whatever reason, and let's suppose that that's valid. And then one of them decides to offer TEFL as well as all the other things it's doing. That's the magic key, is it, for everything that's educational to be exempt, and the institution which hasn't offered TEFL still gets stuck out in the cold.
Well, again, I come back to the point about that there is possibly something more that an entity needs to do than offer just a single TEFL course. That there may or may not be a qualitative threshold. But in response to your question, if that qualitative threshold is surpassed, then yes, all of your education would be exempt, whereas the other entity that hasn't supplied any TEFL wouldn't get the exemption. That's quite
Isn't
right.
that then a fiscal neutrality point? Isn't that where fiscal neutrality comes in? Because the other entity on that assumption does everything else. It's another educational establishment. It's got all of the same standards. It gives the same sorts of qualifications. In fact, one of your other clients, because it fits very neatly within this hypothesis. But that one can't come within the exemption because it happens not to be offering TEFL, although it's offering the full panoply of educational services. Isn't there then a fiscal neutrality problem?
Parliament has decided that there's something about TEFL providers that differentiates it from entities that don't provide TEFL. It's decided that those are entities who have particular aims that are to be recognised. Whether that has a significant influence on the consumer's decision, I suppose, is a factual question. But Parliament has clearly seen there to be something different about TEFL providers that merits recognition.
Yeah.
The next point is that HMRC criticise us for relying on FBT for 3 reasons. The first is that we're criticised for relying on FBT in the Upper Tribunal for 3 reasons. The first is that the Upper Tribunal's decision is only persuasive, and I take that point, of course, it's only persuasive. The second point is that, and this is paragraph 72b of the revenue skeleton, they say that FBT is only relevant to note 1b, and I say that's not right. You could see from the structure of Mr. Justice Morgan's decision that he deals generally with note 1 and then he applies it to note 1b specifically, so I say it's not so limited. And the third is that Lady Justice Arden is said to have disagreed with what the Upper Tribunal said, and I say the position is slightly more nuanced than that. And the point that Lady Justice Arden is disagreeing with can only be understood in light of the cases that she cites. The final point to deal with is the consequences of what would happen if Note 2 were contrary to EU law. and it said that IMAN needs to rely on direct effect at if note 2 is contrary to EU law. And the simple point we make to that is not so. That would be the case if note 2 and note 1F were both disapplied. Then there would be no domestic hook for IMAN to hang on to. But note 1F is not disapplied. The domestic legislation that you're left with when the incompatible elements are taken away is simply recognition of IMAN because it's a provider of TEFL with no restriction on the supplies it makes that qualify for exemption. So unless I can assist you further, those are my submissions on ground 3.
Thank you very much, Mr. Blades. Yes, Mr. Hill.
Now I just pour myself into a glass of water. Good afternoon, otherwards. So I was going to concentrate now on ground 1. I should just explain before I set off that I shall be making the majority of the revenue submissions, so that my learned friend, Miss Inglis, will be dealing with the part of ground 2, dealing with the FEC argument. So we've split our workload slightly differently to the appellants. Before I get on to the revenues positive case on ground 1, I've got 3 brief comments on some of the introductory points made by my learned friend Ms Shaw this morning. The first was just to explain briefly by reference to page 9 of the first authorities bundle, which was the principal VAT directive, the exemptions. I'll just make a brief point on that. So, my learned friend this morning said that the only exemption without a supplier condition was D, the supply of human organs, blood and milk. But the point that the commissioners make, and which is reflected in the case law, is that in fact the directive identifies 7 particular exemptions as having a supply condition which at least Article 133 then goes on to specify is one where the member states are entitled to impose further conditions on optional conditions on that supply condition. So the ones which are identified in 133 are P, G, H, I, which is R, the exemption we're concerned with, L, M, and N. So 7 of the public interest exemptions in Article 132 are identified as having a supply condition where the member states can apply further conditions. And then within that group of 7, in fact, there are then 5 which have very similar wording. And as the court has seen this morning, as my learned friend accepts, at least in respect of some of the exemptions, I think she referred to B, C and G as being similar to I. We say it is in fact B, G and H, not C, but with the addition of H and in fact also N, which have similar wording to I. The reason we say that is that B, G, H, I and N are the exemptions which all refer to bodies governed by public law and then have a rubric of other duly recognised establishments of a similar nature, or in, which is in B, or in I, other organisations recognised by the member state concerned as having similar objects. But all of that group of 5, B, G, H, I and N, start with the body governed by public law and then allow member states a discretion to recognise other establishments or bodies of a similar nature. I should just, as a footnote, mention N is the one member of that group of 5 exemptions which doesn't have, as far as we're aware, any relevant case law on it. Relevant as in relevant to the issues that face the Court of Appeal. There is one CJEU case that we're aware of, which is called British Film Institute, but we don't intend to hand that up unless the court would be helped by it. We can't find anything relevant to these issues in British Film Institute. It happens to be about N, but it doesn't happen to have anything that's relevant to say on issues before the court today. So it's those 5 exemptions which we say are most relevant, and the court will have seen already this morning that the court in Luxembourg uses, it argues by analogy, and through the line of cases from Kugler, Dornier and Kingscrest and then onwards, it has interchangeably referred to cases under one of the headings in the other categories. So what I'll get to in a moment, well, we say that if we can establish that our argument is right as to whether one applies fiscal neutrality by the consumer perspective, we say not, in respect of B, G and H, then we say that that must also apply to I. And from what I understood from my learned friend's submissions this morning, she appears to accept that, i.e. the same considerations apply to each of B, G, H, or I think she accepted B and G must apply to I. But there was one other thing I just wanted to mention before I get onto my submissions on that. And I just briefly wanted to clarify a couple of points on what the first tier tribunal had decided and the upper tribunal. And there were two points there. The first was,
We're going to the FTT first, are we?
yes please. So 168 was the on page 138 was the FTT's decision that the regulatory regime for universities was significantly stronger than the regulatory regime for APs with designated courses. The differences were not simply a matter of detail, but were a matter of degree and substance. And they arose from the additional regulations applicable to obtaining DAPS and obtaining a university title. And then that was upheld by the Upper Tribunal. Just going to find that now. I'm just trying to find. I think there was a question to Ms Shaw this morning on that.
There's a bit in paragraph 20
Yeah.
of the Upper Tribunal, page 80. They refer to paragraph 168.
Yes.
Paragraph 57. Again, refers to ones.
Yeah.
Yes, that's. Yeah, and so the there was a question, I think, to Ms Shaw this morning. I've forgotten from which of your lordships asked the question, but what was the status of that finding of fact by the FTT in the light of her arguments. The point, just simply to be clear on, is that my learned friends did appeal against or did challenge the FTT's findings of fact before the Upper Tribunal, and we'll see that, in fact, in 57 on page 88. And you'll see that in the middle of 57, Ms Shaw said that it seemed that the FTT preferred Ms Lapworth's evidence, which was inconsistent with documentary evidence. The FTT stated in 168 that the differences arose from the additional regulations applicable to obtaining DAPS and obtaining a university title. Those differences were set out by the FTT in 62 and 80 to 82. We considered that was an evaluation of the evidence presented to the FTT, and insofar as there were any conflicts, a conclusion on the facts that it was entitled to draw. Accordingly, we considered that the FTT was entitled to come to the conclusion it did in 176 and 177. So the point I'm making is that 168 was challenged in the Upper Tribunal, but that challenge hasn't been maintained to your Lordship's court. So she has to rely on her point about the what the approach to fiscal neutrality is, but based on the factual findings by the FTT.
Is that one of the grounds on which permission was sought but refused, or was it didn't?
I've forgotten now, but so there isn't permission to
Certainly
re-argue.
There isn't permission to re-argue
the argument at 57. The other point, it may be something which the this court is fully aware of, but one of the three appellants in the FTT, which was IMAN, argued that they were a college of a university. So as well as making the various European arguments, they had an argument of English law, which was that they satisfied the college of a university requirement in the UK law, which you saw this morning. And the FTT looked at the various factors that were set out by the Supreme Court in SAE, and on balance, to summarise, the FTT accepted that IMAN did satisfy some of the SAE factors, but on balance decided that IMAN was not a college of a university. And we'll see that in the FTT decision at 193 to 241, which is at pages 143 to 148. So IMAN had relationships with two universities. One was the University of Wales and the other was London Metropolitan University. And you'll see the careful analysis by the FTT judge, where he went through each of the factors set out by the Supreme Court in SAE by Lord Kitchen, accepting that some of the factors were satisfied, but on balance he decided that neither relationship with either of those two universities made IMAN a college of either university. And that argument was not appealed to the Upper Tribunal, certainly permission wasn't granted, and we'll see that in the Upper Tribunal decision at 22. Which is on page 80.
Yeah.
This is what was called issue 3.
Yeah.
There was no appeal. So that just really explains a bit more of the background. As far as my submissions on...
Can I just ask you before you move on from 168 in the FTT, as I may have misunderstood this, but I thought Ms. Shaw was saying that even if there was a finding in relation to universities, there wasn't in relation to colleges of universities. That's what I understood her to be saying this morning, a bit right at the tail end of 168. Is that right? Is there a...
That's correct, yes.
Yes.
I don't know whether you want to think about that.
I'll think about that, but my immediate I will have a think about the detail of that, because obviously there's a technical aspect to that, but the one thing that I would want to possibly think about is I remember Lady Justice Arden, as she then was in FBT, pointed out that in order to become a college of a university, one had to be sufficiently integrated and share the values of the parent university. So I'd want to just check what she said on that, and therefore...
Well, that's what Lord Kitchen said in the passage you've just shown us from the FTT. It's all about integration.
Yes. But then what does that mean for the regulatory regime? I better check exactly what was said, but to what extent does, if you are integrated, are you then subject, is the university then effectively responsible for its child, as it were, or the entity of which it is the parent? I'll have a think about that overnight, if I may. So the order in which I was going to take my submissions, my positive case on the first point was to effectively make three stages to the argument. First is to look at what the principle of fiscal neutrality actually requires. Then look at how the court has applied fiscal neutrality to the similar exemptions, excluding little n, but points B, G and H. And in respect of those, we say, as the court saw this morning, it applies the Kugler guidance. But we say, one, the two important points there is, one, in none of the times that it sets out the Kugler guidance, does it, as far as the supplier condition is concerned, does it mention specifically the consumer, looking at things from the consumer point of view, or fiscal neutrality from the consumer point of view. But secondly, in each of the many cases in which the court deals with the member state discretion and how member states should exercise that discretion under points B, G and H, the difficulty is, and really this is picking up on something Your Lordship, Lord Justice Lewison has pointed out several times today, which is how do you reconcile the guidance given in each of those cases, and some of it is quite specific, with then an analysis of fiscal neutrality from the consumer perspective, because some of the factors are ones that the consumer couldn't know about. Some of the factors are ones which the consumer might not be able to evaluate, even if he or she knew about them. And some of them are factors which the consumer might not care about when choosing what to buy, whether a good or service, but they might be ones which are very important from the point of view of the state or the relevant regulators. I don't want to trawl through each of these cases and just point out the Kugler rubric in each case, but what I would like to do is look briefly at how the court has applied the Kugler Dornier King's Crest guidance, specifically at the end of each case, and then when asked oneself rhetorically, how is that guidance in that specific case consistent with my learned friend's case that one assesses fiscal neutrality from the consumer perspective? And then thirdly, I was going to, if I can establish that in relation to points B, G and H, we say you can apply that to point I. Now, it would appear that there seems to be some acceptance by my learned friends that what the court says in at least some of the other points, I think my learned friend referred to at least to B and G, is applicable to I, but so I may not need to go into too much detail on that, but I will briefly make my points on it to make sure that the court understands the points I make, that the same analysis as we make in respect of B, G and H applies equally to I. I could go on to rank now. I know that the court has a hard deadline at 4:15.
Yes, it's a hard deadline at 4:15, but you might as well spend 10 minutes on rank.
I'll do that. So the point, what we say about rank, which is at tab 32 in the authorities, so my learned friend emphasised several times that she says that there isn't really so much as a supply and a supplier condition. She says really there just is a supply with two features to it, identified in each of the relevant exemptions in Article 132. And that's why she says you can apply rank to all features of the exemption when assessing fiscal neutrality. The point about rank, though, was that it was very specifically about effectively minor differences in what was being supplied. Because rank was a case about slot machines and something called there's an MCB, which I think stands for Mechanised Cash Bingo. And there was a very perhaps arcane distinction between different types of games, electronic games of a sort of slot machine type character, some of which were entitled to the exemption and some of which weren't. So one will see from just to begin with, at 4, the relevant exemption was what is now the exemption in 135. So this was not a 132 exemption. This was in what's now 135 for betting, lotteries, and other forms of gambling. And we'll see that on page 635 in paragraph 4. So it used to be in little f. We'll see that at note C on the side of the page. I think Lord Justice Miles is correct that the numbering in 135 has since changed. My own friend Ms. Shaw is right that it hasn't changed in 132, but betting, lotteries and gambling are now at point I in 135, whereas previously they were at point F. But you'll see that exemption allowed member states to lay down conditions and limitations, but that was in respect of the type of supply that was exempt, i.e. betting, lotteries and other forms of gambling. So the conditions were to what was being supplied and not who was supplying it. And then we'll see at 14 and 15 that, which is over the page at 636, that rank sought a refund from, or a repayment of taxes paid on mechanised cash bingo and slot machines. And at 15, those actions were essentially based on the argument that the different types of MCB and slot machines were treated differently for the purposes of exemption from VAT, although they were comparable, indeed identical from the consumer's point of view, and that accordingly the fact that certain types of MCB and slot machines were subject to VAT breached the principle of fiscal neutrality. So what Rank was saying is what is being supplied by us is identical to what is being supplied, or materially identical to what is being supplied by other people who are exempt, the revenue acceptor exempt, but you're not allowing us exemption for what we supply. So it wasn't anything to do with who was supplying it. There is if one is interested in the detail, there is more about that in 17 to 23. But to summarise, for mechanised cash bingo, the exemption only applied if the stake was lower than or equal to 50 pence and the prize lower than or equal to £25, otherwise it was taxable. You'll see that at paragraph 17. And for slot machines, the Court of Justice explained at 19 that the exemption didn't apply where the machine was a gaming machine, under Section 26 of the Gaming Act 1968, which the Court of Justice refers to at 9, and that turned on whether the element of chance in the game was provided by means of the machine. And then the Court explains at 20 that the element of chance in the rank machines was provided on demand by the gaming software incorporated in the machine, but then at 21 and 22, there were two comparator types of machine where the random number generator, which provided the element of chance, was outside the machine, i.e. there was some sort of centralised computer chip or whatever, which wasn't actually in the machine. And those machines were exempt in the UK. So you see that at 21 and 22. And then at 23, the Court of Justice explains it was undisputed that the tax Part 3 machines, and which were the rank machines, and the comparator machines were similar from the consumer's point of view. So the issue in that case, you'll see below that at 23, is the Commissioners denied that the two categories of machines were in competition with each other and that the comparator machines were actually exempt under domestic law. So that there was a question as to whether one had to not just say that the machines were similar from the consumer's point of view, but also actually prove distortion of competition as well. What all this really explains is that the case concerned the comparability of the various types of supplies, what was being supplied, and therefore the whole of the court's analysis in rank turns and was focused exclusively on the supply condition, what was being supplied, and not on who was supplying it. And therefore, the whole of the passage that the appellants cite, which is at 32 to 36, which refers to treating similar goods and supplies of services differently for VAT purposes, being contrary to fiscal neutrality, that was an analysis of fiscal neutrality in a case which related wholly to what was being supplied. Then the court went on to say at 34 you didn't need to go on and establish the the actual existence of competition or distortion of competition in 35. And then at 36, the principle of fiscal neutrality must be interpreted as meaning that a difference in treatment of two supplies of services which are identical or similar from the point of view of the consumer and meet the same needs of the consumer is sufficient to establish an infringement of that principle. Such an infringement thus does not require, in addition, that the actual existence of competition between the services in question or distortion of competition because of such difference must be established. But all of that analysis related just to what was being supplied.
Yeah.
Anyway,
All right. Well, if there's more you want to say on rank, we can do it tomorrow.
Very cool.
10:30 tomorrow morning.
Right, if able.